Welcome to Dementia-Friendly Prince George's County, Maryland Northern Sector webinar series for caregivers. Today's topic is Estate Planning 101, sponsored by Prince George's County Government and the Department of Family Services.
Okay, so this is going to be our last presentation of our last webinar of the year. We're going to be taking a break for the holiday season. So we'd like to wish you all a happy holiday season, and we will be back in 2023 with some more webinars and interesting topics. And that is it. So without further ado, I'm going to go ahead and introduce our presenter for the evening, which is Miss Johnine Clark, Esquire. She's going to be presenting about the basics of estate planning, why it's important, as well as some key components to include in your estate planning process. So without further ado, Miss Johnine Clark.
Well, good evening, everyone, and thank you so very much, first of all, to DFA, Northern Prince George's County, as well as the city of Greenbelt. And of course, I would have to thank my wonderful host, Ms. Kalenki, for her time and her ability to assist me this evening. So this is going to be very informal. I'm going to go over 3 basic documents that every estate plan should have. And then hopefully I'm going to open it up at the end for some questions, and hopefully this will be interactive. There may be some questions you have about estate planning that go outside of what I'm presenting tonight. So I wanted to be a resource and be able to give you as much information as I could, but also answer any specific questions that you have. Keep in mind, I am an attorney. Keep in mind also that I would just ask that you be very cautious about sharing any personal information. We don't necessarily want that to be something that others could view. If there's a question that you have that requires more specific answers with respect to your particular issue or question, I would just ask that you either email me or give me a call, and that information will be provided to you later on in the presentation so that we can make sure that we always abide by maintaining confidentiality. So if we could go to the first slide, please. Okay, so there's 3 basic documents that every person should have in what I call their estate planning arsenal. The first one is a power of attorney. Now, what is a power of attorney? A power of attorney is basically a document where you're naming an individual who can carry out tasks or transactions on your behalf. It has to be signed. It has to be notarized. Now, some of the things that you could allow this individual, and we call them an agent, okay, to do for you is that during the time that you're incapacitated, they would be able to sign a legal document for you. They could open a bank account for you. They could have a conversation with the IRS if necessary. You can customize this power of attorney and say specifically what actions the person can take for you and when that person can act on your behalf. There's durable, there's general, and there are limited types of powers of attorney. So the difference between the 3 is basically what specifically you want your agent to be able to do on your behalf. Now, the important thing to keep in mind about a power of attorney is this document only comes into play when you are in a position where you cannot make these decisions on your own. So say, unfortunately, if you have an accident and you are in the hospital and you are not able to pay your bills on your own, that's when the power of attorney would kick in. It wouldn't kick in if you're healthy and you're able to pay your bills and all of that on your own. It would only kick in in the instance where you're not able to do these normal things that you would do on your own. And then you're saying, I'm going to allow this particular agent, my agent, this individual that I've identified, to be the person that can step in while I'm incapacitated to make these decisions for me. As soon as you get healthy and you get out of the hospital, then the power of attorney ends. Also, keep in mind that this document only is in effect while you are alive. When you pass away, the power of attorney extinguishes as well. Okay? All right, if we could go to the next slide. Okay. Another document that you want to have now, actually, I think there's, another document that you want to have is you want to have all of your HIPAA information or your HIPAA authorization in place. What is HIPAA? So HIPAA stands for the Health Insurance Portability and Accountability Act. I'm sure a lot of you have heard of this or heard of HIPAA or have heard people use that acronym before. Basically, what you're doing with a HIPAA authorization is, again, if in a particular situation, someone needs to have access to your health information, say if you are in a nursing home and they want to transfer you to another nursing home, or you're in the hospital and they want to transfer you to another hospital, or if they want to be able to look at your health records so that they can just be able to see for themselves what actually your diagnosis is, and they can make some decisions for you based upon that diagnosis, you would have to have completed a HIPAA authorization. Your information, your healthcare information, is private information, and an individual can only get access to that information if you have given that person authorization. If you have not, then a hospital, a doctor cannot legally give you that information. So in this particular document, in this authorization, there's specific language that has to be in that document. For example, it has to say, for all purposes related to this document, my agent, again, the individual that you've identified that's going to be able to retrieve this information, is my personal representative of the Health Insurance Portability and Accountability under the Health Insurance Portability and Accountability Act. You have to have that specific language within your HIPAA authorization in order for it to be effective. Then you also have to have another paragraph or a line that says, my agent may sign as my personal representative and release forms or other HIPAA related materials. So if you have a HIPAA authorization that does not include this language, neither a hospital or doctor or other healthcare provider or anyone that holds onto your health records will be allowed to give those documents to your agent unless that language is included. So we have a power of attorney and we have a HIPAA authorization. Let's see what else you have to have included in your basic estate planning arsenal. We can go to the next slide. Okay, I'm sure everyone has heard about a last will and testament, but you would be surprised that in my experience, very few people have a last will and testament in place. So, what does a last will and testament do? It is your opportunity to, number one, identify an individual who will be responsible for making sure that all of your assets and all of your desires are realized or accomplished once you pass away. So obviously, you want to have a personal representative identified in your last will and testament that is someone that you trust and believe that this individual is going to be someone that is going to abide by your wishes. Also, within your last will and testament, you want to identify what's going to happen to your property. So, for example, if you have a home, who will get that home? If you have mementos or family heirlooms that you want to be passed down from generation to generation, who will get those? Who will get the furnishings in your home? Who will get your automobile if you have one? So keep in mind, you want to be very specific about who is supposed to get what once you pass. That is so important because the more clear you are about who gets what in your will, the easier it's going to be for your personal representative to make sure that all of your affairs are taken care of according to your wishes. Also, what if you have minor children or you're the guardian for a minor child? You can put in your will what is supposed to happen to that minor child as well, who you believe would be a good person to have custody of that child. Now, there's a proviso with that. Not only do I practice estate planning, I do family law as well. So keep in mind, in this particular instance, even if you were to identify someone as the person that you wished to now have custody of a minor child, once you pass, if that child has a living parent, that parent may be able to go into court and may be able to file for custody of that child. So you have to balance your desires versus the possibility that a parent may have superior rights now that you have passed away and be able to claim custody to that child. Keep in mind, a will, unlike a power of attorney, is only effective at your death, and it does not avoid probate. Now, I've heard a lot of people say, oh my goodness, probate is the worst thing ever. I don't want my relatives, once I've passed, to have to pay estate tax and all of that. Understand that once you have a will in place, a personal representative will go to the Register of Wills in the county in which you live, and they will open an estate anyway. What's going to make this different and to avoid the estate taxes and the other things that you have concerns about is the specifics of what is in your last will and testament. So, and a lot of people think that, estates and probates, it takes forever. It does not. In my experience, when people have their affairs in order, it's a very simple process. It's a matter of filing those documents so that a court can have an opportunity to review them, and then your personal representative will complete all of your wishes, make sure that everyone in your will gets what they're entitled to, and then the estate is closed. So probate is not as bad as people may think, and it's just a streamlined way of making sure that it's like putting some more eyes on your estate to make sure that everything that you wanted to happen in your will happens according to what you have requested. So I just want to recap a little bit. You have your power of attorney. That's the first thing that you want to have, right? The second thing that you want to have is you want to have your HIPAA authorization completed. Now, keep in mind, those two documents will only be in effect while you are alive. As soon as you pass, the HIPAA authorization is no longer in effect, and the power of attorney is no longer in effect. And then you have your last will and testament, which is when you pass, it goes into effect. So what I try to recommend to all of my clients and everyone that I speak to is that you have all of these pieces in place so that you're covered while you're alive and you're covered after you pass. Next slide, please. Okay. Before we get to questions and answers, again, I just wanted to give you a basic overview. There's one more document that I would suggest that you consider, and it's called an Advanced Healthcare Directive. Now, I don't have a slide for this, so you have to listen really close to what I'm getting ready to tell you. An Advanced Healthcare Directive is, again, a document that you have in place in your estate planning arsenal and is in effect while you are alive. What that document does is it identifies a person who will be responsible for making the ultimate medical decisions for you should you end up in what is known as a vegetative state. That person identified in your healthcare directive will be able to say to a doctor, again, according to your wishes, whether or not you should be kept on life support or you should not. So you want to make sure that your healthcare directive has who you trust to make that decision for you. The other thing to keep in mind for all of the 4 documents that I've mentioned this evening is that you may identify, for example, in a will, let's just call this person Susie. So you've identified Susie as being your personal representative. I always recommend that you have a secondary personal representative. So if in fact something happens to Susie, you have someone else that will be able to step in and still complete your affairs. Like, you won't miss a beat. Everything will happen according to how you would like, but again, you're having a contingency. So if something happens to Susie, then Bill, your secondary personal representative, would be able to step in and do whatever you requested of Susie in your will. Just like in the power of attorney, you may identify an agent, but then you may have a backup or a contingent agent. So if something happens to your first agent and they're not able to complete what needs to be completed according to your power of attorney, then you have someone else that could step in. Similarly to your HIPAA authorization, you may authorize maybe a son, a daughter, a sibling, but if something happens to that individual and there's a need for someone to have access to your health records, you can always identify someone else that would be able to step in. I always make that recommendation that you have a contingency or a secondary agent identified in your documents to make sure that your wishes are still carried out. So that's just some of the things that I wanted to share with you. Estate planning can be very involved. What I did want to leave with you before I take questions is that the estate planning, what I've just described to you, is a small part of it. I always ask that whenever you're thinking about estate planning, yes, you want to have your legal documents in place, but you may want to also have your investments considered and how are they going to affect your estate plan. You may want to also look at something else like a life insurance policy. Life insurance policies are considered part of an estate plan. And the awesome thing about a life insurance policy is that your beneficiary does not have to go through probate. They don't have to go to the register of wills. That money automatically becomes that person's money upon your passing. Keep in mind, though, if you identify in your insurance policy a minor, that minor would not be able to take those funds until they were 18 years of age. So what has to happen is a guardian has to be appointed for that minor. They have to open up an account for them with the court. They have to, every year until that child reaches 18, report back to the court how much money they have in the account, if there was any withdrawals from the account, and what for. And then at 18 years of age, that child gets that money. And, an adult doesn't have any control over that. That's just their money. So keep in mind that what I've shared with you tonight is just a part of your estate plan. You want to look at the big picture, and you want to make sure that your wishes are going to be kept and honored either in a last will and testament or before you pass a power of attorney, the HIPAA release, or the advanced healthcare directive. Lastly, I'm going to give you a little tip. This is my tip for the evening. One thing that you can always do is you can always put someone's name on a bank account, checking account, savings account. You would share that account jointly. A lot of times there's lag time between when a person passes and when an estate can be open. And so there's time where your personal representative may not have access to money. So if they need to bury you, or if there's some, emergency expense that comes up, they're not able to take care of that because they don't have access to money. So one tip I would suggest is that you have an account with maybe, a few $100s in it, maybe, a few thousand, depending upon your budget, that you would put aside, put someone else's name that you trust as a joint owner of that account, so that when you pass, they have access to that money so that they can take care of any immediate financial needs until the estate is open. So that's just some of the things that I wanted to share with you all. And now, if there are any questions that you have, I would be more than willing and happy to answer them at this time.
Okay, thank you, Ms. Clark, for coming and sharing this information with us. We know that estate planning is very important, and it's just one of those topics that people do not think about or discuss nearly as often as they should. So we thank you for coming and sharing this information with us. I'm going to take a look at the chat to our audience if anyone has any questions that they would like to ask. Ms. Clark, you can put that in our chat and I will share that, and we will go ahead and work through any questions that there might be.
Yeah. And it doesn't have to be limited to what, I've discussed tonight. If there's something else, within estate planning that you'd like to ask a question about, please feel free. Okay. Wow, did I answer everyone's question? I did a great job, didn't I?
Right. Yes, no questions as of now, nothing in the chat. Okay. I'll give
hopefully I gave them something to think about. Maybe that's
something to think about. And then your contact information is on. Let me go ahead and put that slide up. Contact information is here on the last slide, which is in our handouts that we have attached to this event and webinar. So if you're interested in contacting Ms. Clark, you can do that with the information listed. Okay, so we don't have any questions, so we're going to take that as that you did an excellent job and all questions are
I'm going to pat myself on the back.
Yeah. And thank you again. So this webinar is going to be posted for anybody who maybe came in a little bit later, missed the beginning part of it. You can go onto our YouTube page and you'll be able to see that as well as this webinar as well as all of our past topics that we have had. And we thank you for joining us. This is our last webinar of the year. And we will be back in January with more interesting topics. So thank you, and everyone have a good
Absolutely.
evening.
And Ms. Kalenki, I
Yeah.
did want to share, if anyone that is listening to this webinar or participated this evening, if you when you contact my office, if you have a question, if you let my receptionist know that you attended this webinar or you heard or are viewing this webinar, I will give you a free assessment of where you are now in terms of your estate planning and give you some tips for how you could get your estate planning going and in good shape. How about that?
Awesome. Thank you so much, Ms. Clark. Thank you for joining us this evening. All right.
Thank you
So
so
everyone
much.
have a good evening. Thank you. Good night.
Happy holidays.
Happy holidays, everyone.